Hello and welcome to this bite-sized training session hosted by FARRAR'S Building. My name's Lauren Jones. I'm a junior tenant at FARRAR'S Building, and I'm going to be talking to you for 15 minutes about the basics of witness statements. Okay, starting with the absolute basics, I've included on the slide some definitions or descriptions of witness statements taken from the civil procedure rules. You can see in the middle there that paragraph 20 of practice direction 32 says that a witness statement is the equivalent of the oral evidence which the witness would, if called, give in evidence. So that's what we're aiming for with a witness statement. At the bottom there are some must-haves in relation to witness statements. So a witness statement needs, if possible, to be in the witness's own words, and in any event, it needs to be in the witness's own language and expressed in the first person. There are also some facts which need to be included in all witness statements, and those are set out at the bottom of the slide. Things like the witness's full name, their place of residence, their occupation. And you can find the list of those facts at paragraph 18.1 of practice direction 32, as you see on the slide there. Okay, as we all know, in civil proceedings, a witness's witness statement will stand as their evidence in chief as the general rule. That is supplemented by rule 32.53, which you see on the slide there. And that rule says that a witness giving oral evidence at trial may, with the permission of the court, amplify their statement and give evidence in relation to new matters which have arisen since the witness statement was served on the other parties. The court will give permission under paragraph 3 only if it considers that there is good reason not to confine the evidence of the witness to the contents of his witness statement. So there will obviously be circumstances where you will need to be relying upon 32.5, for example, where new things have come to light since the drafting of the statement, or new events have occurred since the drafting of the statement. The discretion is there. If you are aware of all of the relevant facts at the time you're drafting the statement, then it's really important to make sure that they all go into the witness statement, that you have everything in there that you know you're going to need in order to prove your case, because you don't want to be relying on this discretion if you could avoid it, because of course it is a discretion and the judge might not choose to exercise it. Part 32 doesn't apply to the small claims track. Part 27 essentially says that a judge can conduct a small claims hearing in whatever way they think is fair, but similar considerations are likely to apply, and a judge is going to exercise their discretion in a similar way. Okay, we're going to be looking at 4 key principles which are handy to have in mind when drafting witness statements, and those are taken from the handbook for litigants in person, and that handbook was written by 6 circuit judges. You can see the 4 principles set out on the slide there. The first is to tell the story in chronological order. The second is that the factual issues in the case should all be dealt with. The third is that the witness statement is a statement of fact, not a statement of opinion. And the fourth principle is that the witness statement must be true. We're going to go through each of those 4 principles in order, and then at the end we'll have a look at exhibits and foreign language witness statements. Okay, starting with number 1, tell the story and tell it in chronological order. You can see that paragraph 19.2 of practice direction 32 specifically says that it will normally be convenient for a witness statement to be following a chronological sequence of events, and for each paragraph, so far as possible, to relate to a distinct portion of the subject matter. So you want it to be in chronological order. Set the scene. Remember that this is the first time that a judge, it's probably the first time that a judge is visualizing this particular place or this particular day. So describe the layout of the premises or the road that you're talking about. What time of day was it? What was the weather like? Maybe describe the traffic conditions. Allow the judge to visualize the scene. Focus on the accident or allegation of negligence. You're obviously setting out a chronological sequence of events, as we've said, but you of course want to avoid there being a lot of irrelevant material in there which doesn't really relate to the allegations the court needs to deal with. Some facts are best understood using documents. Where that's the case, then exhibit the documents and explain them. To take a really obvious example, which you will all have come across, if a witness is describing damage to their vehicle, then the best and easiest way for a witness to do that is to describe it in words in their statements, but by reference to an engineer's report or photographs of the vehicle, rather than just trying to describe it using words alone. Make sure the witness understands. That's an important one. If you include complicated legal points in the witness statement, the witness isn't going to understand them, and the witness isn't going to be able to explain them if they're asked about them under cross-examination. So avoid doing that and make sure that your witness understands everything that is in the witness statement. Number two, then, the factual issues in the case should all be dealt with. The best way, I think, of achieving this is to start by going back to the particulars of claim or the defence, depending on who you're representing, and have a think about what it is that you need to establish in order to prove your case. What facts do you need to establish to either prove or disprove the allegations made in the pleadings? And those are the facts that you're going to want to include in your witness statement. You also need to make decisions about how to deal with unhelpful facts. It's a judgment call what to do about unhelpful facts, and you want to strike a balance between having a strong negotiating position in relation to any settlement discussions that you might want to have before trial, but also the risk of damage to your witness's credibility if unhelpful things come out for the first time at trial. So it is a judgment call, and you need to make a decision based on the facts, but it's often helpful and sensible to deal with unhelpful facts head on, in my view. Try to avoid responding to allegations by making submissions or statements of opinion. So an example of that is, I'm astounded to discover that the claimant says I was speeding. Well, the witness probably is astounded to hear that, but saying it doesn't add any facts which will help to disprove the allegation that they were speeding. So it's not particularly helpful, and it doesn't need to be in the statement. Avoid making vague statements. We've already covered this slightly in relation to CPR 32.5. If you're describing something, just make sure that the description isn't in any way vague, because that again puts the witness in potential trouble during cross-examination. Number three, the witness statement is a statement of fact, not a statement of opinion. You can see there on the slide that paragraph 18.2 of Practice Direction 32 specifically says that a witness statement must indicate which of the statements in it are made from the witness's own knowledge and which are matters of information or belief, and also identify the source of any matters of information or belief. You need to distinguish in your witness statement between what the witness knows to be true and what the witness has assumed to be true, and explain the reasons for any assumptions that have been made. That's going to be much more persuasive, and it's going to be much less vulnerable to attack under cross-examination. It doesn't look very credible if a witness is stating assumptions as facts. So there's an example there on the slide. The claimant knew Mr. X before the collision, an assumption stated as a fact, versus I don't know whether or not the claimant and Mr. X knew each other before the collision, but I assumed at the time that they did because the claimant referred to Mr. X by name at the scene before Mr. X had introduced himself. Much more persuasive, much less vulnerable to attack under cross-examination. Try to avoid making wild allegations. The claimant was drunk, the claimant was on drugs, the claimant has a problem with road rage. If you've spoken to your witness and there are some facts that may mean the allegation is founded, then it can be included, but it needs to be supported by fact, and it isn't helpful if those allegations are just flung around in a witness statement. Number 4, the witness statement must be true. Obvious, but there are some relevant points to take into account. So make sure that your witness has read the witness statement and the statement of truth carefully before they sign it. And when they're reading it through, make sure that they are looking to see whether all of the details are accurate, rather than just reading it to get a sense of whether it's broadly accurate, which is understandably what quite a few witnesses do. It can be quite damaging to a witness's credibility at trial if they've got to make lots of changes to their witness statement before they're able to confirm that it's accurate. So get them to read it through before they sign it, and get them to be checking closely for accuracy. It's also often a good idea to send all of the relevant documents, so pleadings, disclosure, things like that, to the witness and ask them to comment and make them aware of what the other side's case is. Finally, on this slide, make sure that the witness rereads their witness statement before trial so that it's all fresh in their mind. Okay, those are the 4 key principles. We're now going to have a look at exhibits and then finally foreign language witness statements. So documents should always, if possible, be exhibited and referred to in someone's witness statement, rather than just being included in the bundle as separate documents. As you can see, paragraph 18.3 of Practice Direction 32 says that an exhibit used in conjunction with a witness statement should be verified and identified by the witness and remain separate from the witness's statement. And the bullet point below that shows you how a witness should refer to an exhibit. They should say, I refer to the, and then a description of the exhibit, so engineering report, whatever it is, marked, and then the name of the exhibit, and that will be the witness's initials and then the number of the exhibit. There are some other helpful provisions on the slide there in relation to witness statements, which I'll allow you to, I'll leave you to read in your own time. Foreign language witness statements, where your client doesn't speak English as their first language, then these provisions are going to be particularly relevant to you. All witness statements now need to state the process by which they've been made, so whether it was face-to-face, telephone, but they should also state if they've been made via a translator. And I think probably it's helpful to describe how that was done if that's what you're doing. The witness statement must be in the language of the witness, and in the top right-hand corner on the first page, it needs to state the date of any translation. At the bottom there are some steps that you need to follow if you're wanting to rely on a foreign witness statement. You need to have it translated. You need to file the foreign language version, which means file both the English version and the foreign language version. And you need to have the translator sign the original and certify that the translation is accurate. So those are the steps to follow. Part 32 of the CPR doesn't apply to the small claims track, as I've said, but in my view, following these provisions anyway is the safest way to deal with foreign language witness statements, even on the small claims track. Okay, that concludes our session. Thank you very much for listening. I hope that it's been helpful for you all. As you can see at the bottom of the slide there, if you refer to the knowledge base tab on our website, there are some further bite-sized training sessions on other topics there. If you think that you would like some more personalised or in-depth training, then please do contact our marketing manager, who will be more than happy to discuss your requirements. Thank you all for listening.